about the reform of the package travel regulation next. We're going to ask, are they fit for purpose? And to talk about that, we have two members of our temporal chambers. We have Daniel Clarke, known to many of you, I'm sure, junior counsel to Sarah Crowther in both Court of Appeal and Supreme Court in Bramley, a very seasoned and indeed a leading junior in travel law, both in Legal 500 and in Chambers and Partners. A very special welcome to Lorna and Badham. I say very special because I think this is her first Temporal Travel Conference, certainly in Manchester. Again, a broad specialism across these fields, dealing with international illness and accidents, and a rising star in the Legal 500.
Welcome to our talk about reform of the package travel regulation. So Lorna and I are going to talk about some of the potential and proposed changes, both from an EU and a UK perspective, to the package travel regulations, but not in such a way that it's going to keep you from your tea break, because as Gerard says, that's the really important thing, and that's what we really come for. So just a little bit of a background and overview, but not a massive amount, because you're all very expert in this area. So I don't need to go into a lot of background before Lorna starts to explain what the actual proposed changes are. But I suppose the first point to make is that the regulations have been a central feature of the travel law landscape for about 35 years. And for that time, most of that time, they've been very stable, changed a great deal. And we're now entering a period, a time when things look a lot more volatile in terms of what the actual content of the regulations are going to be, certainly from certain aspects anyway. And that potential change, as I say, is going to come, or it seems likely to come, both in the EU and in the UK. And so for the first time since 1990, the package travel regs in the EU and the package travel regs in the UK are going to start, it seems likely anyway, to take different paths, to bifurcate, to have different regimes. What's driving the change? Well, I mean, the pandemic's a big reason, as we'll see when Lorna talks about the EU changes. I mean, that's driving it both within the EU and the UK. The collapse of Thomas Cook as well. That's another driver for both the EU and the UK change. And obviously, within the UK, there's the newfound freedom and nimbleness that we possess now post-Brexit to edit, repeal, amend, change, improve, deregulate, however you want to put it, from the directives and law that we previously shared with everyone else in the EU. From another perspective, though, the changes are not as profound as you might expect. The liability regime under the package travel regs, both as it exists now and as it's proposed, doesn't look that likely to change. And I think one of the general things that I would draw out from this is that a lot of these changes are really driven much more by economics and the bottom line of tour operations. They're much more focused on refunds for unsatisfactory or cancelled holidays than they are directed at personal injury. In fact, really, the primary aim, I would say, of most of these potential reforms is not personal injury cases at all. What's happening is personal injury cases are likely to be affected significantly, but really by a sideswipe. And that's sort of always been the way. I mean, if you think back to 2019, after the collapse of Thomas Cook, there was I'm not sure promise is quite the right word, but there was certainly an indication by the UK government they're going to set up a special scheme to help out the claimants who've been seriously injured and left high and dry by Thomas Cook's collapse. And that was going to be put into place urgently. And then it was just completely forgotten. And it never happened. And there's sort of a continuation of that theme with a lot of these changes. Thomas Cook's collapse is relevant to the changes, but only insofar as they relate to cancellation, refunds, and so on, not really as it relates to personal injury. Next slide, please. So a little bit of background, but not, as I say, a huge amount, because you all know so much about it. The original directive, obviously from 1990, was a big change at the time, and it was very much in keeping with the kind of methodology of the EU, which is to bring rights home to consumers and to claimants, to parties in their own jurisdiction, subject to their own law. So it's very much of a piece with a lot of the kind of jurisdictional rules under the Brussels regime that's existed since 1968. The key concept that it brought in of a package, effectively the kind of gateway to accessing the vicarious liability regime, was an innovation, and the package was defined, as I think a lot of us probably remember, as a pre-arranged combination of at least two components sold and offered for sale at an inclusive price. That deceptively simple definition generated a huge amount of litigation. I mean, you could have cases about whether or not it's a package that turned on the contents of an oral conversation that someone had in a travel agent. And obviously, recollections differed about that a lot of the time, or whether it was a package or not, depending on the email exchanges, and or whether terms and conditions were brought to claimant's attention, in time for it to be passed the contract or not. All sorts of factual scenarios presented themselves. Anyway, that was the definition until 2018. The 1990 regulation was simply copied out into English law without any kind of additional change, which is the usual way of implementing directives. Became the PTR 1992. And it lasted 25 years, which is a really long time, actually. And in 2015, the European Parliament passed a new directive superseding the old one. And that entered into force, as we all know, on the 1st of July 2018. And that's the current regime we have. And the big driver for that change was fitness with digital aid. I mean, if Gaza had decided to console himself after the World Cup in 1990 by going on a package holiday, he would almost certainly have, and maybe he did, he almost certainly would have gone into a travel agent and spoken to someone about it, or rung someone up on the phone, possibly gone on CFAX, or read a brochure. That's what he would have done. And that would have been the way of doing it for probably another 10, 15 years for most people. But probably by the 2010s, I would say that had really sort of got into abeyance, and practically no one does that. It's actually a surprise to see quite so many travel agent stores as you do in some parts of the country at high streets, because it's very much a kind of minority activity now. So the world had completely changed. I'm not sure what Gaza would have said if you talked to him about the internet in 1990. He probably wouldn't have believed you. But anyway, things have changed enormously underneath everyone's feet, and there was obviously a need for a reform at that stage. Thanks, Vicky. And the big change, I suppose, if you're going to bring it down to one thing, brought about in 2018 was the definition package. So that rather kind of tricksy definition, as it turned out, from 1992 was gone and replaced by the list of 6 things that we now have with their substantive definitions, and that enormously broadens the scope of application of the regulation. It is more complex, and it's not, without going into it in too much detail, because that's really for another talk. There are still complexities and loopholes potentially, but it is now much more difficult to sell any sort of combination or several parts of a holiday without it being a package than it was. So the litigation on that front has reduced. But the liability regime wasn't changed. That stayed the same. And the new directive was brought into force in England. Government very proudly said, we're bringing into force this new regime, these new package travel regulations in 2018, and it demonstrates our commitment to consumers. I remember the tweet, as it then was quite well. I thought it was a little bit cheeky that they were, the government was saying that without any mention of the fact that it was an EU directive, as if it were a UK government initiative. But anyway, that's what it did. So that's where we are as it stands with the 2018 regulations. Now, Lorna's going to talk about the proposed EU changes, and then a bit about the proposed UK changes.
Thank you. So we've spoken a bit already about the pandemic and the failure of Thomas Cook. I don't know if anyone remembers when Thomas Cook actually went under.
It was a Sunday, I remember this. It was
a Sunday. Yeah. Any advances on a Sunday?
Gutted.
I remember because I was waiting for the cost for a 3-day multi-track trial in Leicester. client's damages luckily came in beforehand, but the costs came in afterwards. So I'm reminded of it every time I check my balance sheet. It was September 2019 that Thomas Cook went under, and then of course more than 4 years ago now, the pandemic hit. To put it into perspective, I think in May 2020, the European Union Commission estimates were that the travel industry had lost 30 billion in the first quarter of that year and was going to lose 46 billion in the second quarter, which is 76 times the grossing of Taylor Swift's Eras tour, for anybody who wants a direct comparison that's clearly relevant. But arising out of this, and particular times when the travel industry saw mass cancellation of bookings with very little revenue coming in, out in November 2023, there was a proposed directive reconsidering things with the aim of improving and simplifying the directive and strengthening consumer protection. Now, all of this is somewhat crystal ball gazing because it's awaiting consideration by the EU Parliament and implementation. But if we look at what's proposed in the next slide, please. A prime feature is not the liability regime, which doesn't seem likely to change at all, but an expanded definition of the package. So you'll have any website or retail store on which it's possible to purchase 2 different travel services will now be within scope. Possible even where the customer buys the travel services from different websites, and we'll look particularly at that. But if we next slide, please. So in the expanded definition for claims brought under EU law, if I buy my flight online at 12 p.m, go have a coffee, but return to the same website and buy my hotel from that website within 3 hours, it will constitute a package. If I book my flight at 12 p.m. on that website, but before I've checked out, I am advertised and encouraged to buy additional services. I don't do them before I buy my flight, but I return and I buy them within 24 hours. That's also going to count. And if I buy my flight, for example, from one website, click through to another website to buy my hotel, but that first website shares aspects of my personal data with the second website, then that's also going to constitute a package. So the definition is expected to broaden, and it's expected to effectively subsume that first type of linked travel arrangement, which is linked travel arrangements bought at the point of sale. Next slide, please. And they are discussing and considering a limitation on the advance payment so that a down payment can only be 25% of the total cost, and the remainder not payable more than 20 days before the holiday is due to take place. It is anticipated that there will be wiggle room on this if the organiser has to pay more than 25% to the suppliers at the time of booking. But clearly that's some financial protection there. In respect of vouchers, and you'll have heard Karen and Nathaniel speak to vouchers somewhat already, there's no proposal that travellers will ever be obliged to accept vouchers. But in May 2020, the European Commission started to explore how they could make vouchers as an alternative more viable and more attractive so that travellers would choose them as a way of lessening the financial blow to the travel industry in times of pandemic and extraordinary circumstance. And those included, for example, including vouchers and protections against insolvency. I think they're also looking at ensuring the transferability of vouchers and questions around how long they endure and can be used for, so that they can hopefully be a viable alternative that people will want to opt for rather than be obliged to take. Refunds and vouchers should be in the developments all subject to insolvency protections. There is a suggestion that member states may wish to set up crisis funds that can assist organisers in the event of emergency. But the thought is, I mean, firstly, this isn't an obligation. but also that, say, for exceptional circumstances, refunds and vouchers would still be funded by the package organisers rather than member states. The customer's right to cancel, and again, not to tread on their toes, because I know that Karen and Nathaniel spoke already about unavoidable and extraordinary circumstances that significantly affect the package. That's where your refund rights are at the moment. But the proposal is that, let's take that Icelandic volcano and put it at Luton Airport. You might still be covered. They're not directly proposing to me, but that you might still be entitled to refunds if that unavoidable and extraordinary circumstance happens at your destination or at your place of departure, your customer residence, if a volcano happens to be under your house, I'm sorry, or on the way to the destination. If you're taking the scenic route around Naples and going via Vesuvius. I'm sorry, I've not been able to think of any example other than volcanoes since I saw that first slide. So potentially, if we're looking at these changes, if they do get passed through, maybe that case of breakaway would have a different decision later. It's also, and this is very interesting because this is also something that Karen and Nathaniel picked up on. Well, we had official travel advice not being chosen to constitute in the courts an unavoidable and extraordinary circumstance, because the gloss at the moment and the anticipation is that unavoidable and extraordinary circumstance will not be in the developments automatic with official travel advice, but that it will effectively be a factor to be taken into account. So forgive me, that's where breakaway is likely to change. There's something about the denied boarding regulations, which is relatively dull, but just to cover it quickly, the proposal is to allow an airline to repay via an intermediary if that's how a flight was purchased in the event of a refund. So that's the EU position. If we, next slide, please. We have a call for evidence at the end of 2023 from the Department of Business and Trade. Again, it's only a call for evidence, so we see the consultations and the sorts of things that they are canvassing. Point duly noted that if the government changes, the mood may change. But we're seeing in this one far less consumer-oriented language, that the purpose is to drive growth, support businesses and offer cost-effective options to consumers. Cutting red tape, all that sort of thing. They're seeking evidence. One of the things they're keen to know about is how easy organisers have found it to get redress and refunds from third parties in situations such as the pandemic, obviously particularly relevant to the 14-day refund rights if organisers are finding it very hard themselves to get refunds from suppliers. One of the most controversial, if not the most controversial aspects has been that they've been considering a minimum price threshold below which the protections would not apply. And they've been considering either looking at doing that by total price or by average cost per head, by the size of the deposit. Recent statements suggest that that's unlikely to be the case. Who's to say, cynically, whether it's because it doesn't look particularly good to attempt to deny poorer people protections in an election year. But I think many people would probably say that it's right that you remove that sort of consideration from scope if someone's paid for a package. Seems unlikely to be taken forward, that one. But there's consideration of excluding domestic packages from the protections, or of only including domestic packages if they include transport services. Lots of the responses to the consultation, including the response from APL, have been emphasising and sort of urging the government to take action on compulsory insurance for travel organisers. So we wait with bated breath to see if that's something that happens. There's also a consideration of travellers expressly excluding business travellers. The idea being that they may, in effect, be less vulnerable because of the purposes for which they're contracting. So opt out of what is effectively consumer protection law in spirit. And in respect of linked travel arrangements, they are considering either removing them entirely or including them within the definition of a package. So we really have got no idea what's going to happen there. And with that, sorry, yes. I skipped the slide too. And with that, I pass back to Dan at the stand.
Yeah, thank you. Yes, well, I mean, as Lorna rightly says, it is all a bit sort of crystal ball at the moment, because with both sets of proposed reforms, there's an awfully long way to go with all of it. So, it's probably not worth getting too worked up about at this stage, although obviously it's a really good idea to respond to the consultations, as I know many of you already do. I mean, sort of pulling it together, as I said before, I mean, one of the really obvious things is it's a sort of pivotal moment when the UK looks likely to depart from the EU in terms of what the actual content of the package of regulations is. And judging by the nature of the questions posed at the consultation, and judging by what the draft directive says, it looks like it's going to be more favourable for claimants in the EU than it is in the UK. The direction of travel, if anything, in the UK consultation seems to suggest more restrictions on when claims can be brought, whereas it's the other way around, if anything, in the EU. So, I mean, that's interesting to note. I suppose from a practical perspective, the vast majority of cases, we're only going to be concerned with the EU version, sorry, the UK version, not the EU, but it's interesting to note that. Some of the reforms or proposed reforms in the UK proposals are quite hard to argue with, I think. Would obviously be fantastic if there were insurance and easier redress with third parties for tour operators and defendants would benefit everyone, claimants and defendants. So a bit short on detail about how that's going to happen in the proposal, but no one could really argue with the principle. Other things which Lorna was just mentioning, I think are much harder to justify, really. The minimum price requirement, I think, is a really good example of how proposal really driven by bottom line financial analysis, and not really with any kind of PI or inputs. Because I think if you were to ask most personal injury lawyers whether it's right that somebody who was catastrophically injured on a holiday that happened to be relatively cheap to buy should be denied compensation, as against someone may have got mild food poisoning on a very expensive holiday, they would say, well, that's ridiculous and arbitrary. But you can see this, perhaps a bit more of the sense of it if you're just analysing it in terms of bottom line and the kind of claims being quality complaints or cancellations, and perhaps it makes a bit more sense then. So that would be unfortunate if something like that brought in and by a sideswipe brought in a really unfortunate level of arbitrariness to PI claims. Hopefully that won't happen. Domestic packages being removed from the definition might be a bit more of an argument for that, in the sense that the real benefit of the regulations is for people who are injured abroad, and it brings their claim back to their home jurisdiction. It gives them a defendant to sue. And you might say, well, in domestic package claims, unlikely to face those kind of issues if they're injured in England, probably got an English domiciled defendant to sue and so on. So you might make an argument for that, but by the same token, it still seems a little bit bizarre if two claimants identically injured on a package. One had the benefit of the package travel regulations happened abroad, but the person that happened to in England didn't. Why should they be in a worse position? You might say. So, well, we'll just have to see what happens on that. And the removal of business travellers, again, I think is a similar kind of issue. I suppose you could make an argument saying this is about consumer protection. They shouldn't really be included. But from a personal injury lawyer's point of view, just because you got on a working holiday or whatever, or business trip, seem rather unfair if you didn't get the benefits of the regulations as opposed to a pure holiday maker. But I suppose there might be some argument for it. So yeah, as Lorna says, we'll have to see what happens with all of that, and it may be some time, but there's certainly on any view, there's movement. Things are not likely to stay as they are. So we're just going to have to keep a close eye on it. One thing that's missing from all of this is any kind of proposed change or any kind of analysis of the liability regime that we've got under the package travel regulations is that in the UK as it stands. So as everyone here will know very well, we analyse it in these terms. There's an implied contractual term of reasonable skill and care, and the claimant's got to prove breach of it. And to do that, they have to do it by reference to local standards, which almost always have to prove by reference to expert evidence. Not always, but almost always. And that's been the way. I mean, the local standards issue's been sort of up and down, in and up the courts for a long time, but probably settled for at least 10 years. But that's apart from that, it's been the way for over 20 years, probably since home and going places. Now, there's a really good argument for saying that that should never have happened. That wasn't what the package travel regulations actually envisaged. They envisaged a regime which was essentially a strict liability regime. Essentially, if you a claimant, holidaymaker, were injured during the course of or by virtue of the services offered pursuant to a holiday contract, you would have a claim unless the defendants could avail themselves of one of the defences in the regulations. And that is how it's been implemented and interpreted in other EU countries. Not an uncommon way of structuring liability in lots of other EU countries and civil law countries in particular, which is not something that we're very used to. And one of those countries is France. I'm really pleased to see Monsieur Ricard here, because he could probably tell us all about it afterwards. But that's the position in France, and that was evidenced and litigated in Commentary and Club Med in 2018. And there's a really good argument for saying that English law took a wrong turn 20 years ago in home and going places, and that we never should have ended up in a position where you needed to prove negligence. We never should have ended up in a position where you needed local standards evidence, almost always in expert form, to prove the breach. And you could imagine things being the advantages of not having to do that from everyone's perspective, because proving local standards is a bit of a millstone, not just for claimants, but also for defendants. It's expensive, it could be difficult, it makes everything really complicated. And the costs of and the efficiency of litigating claims would be much improved if we hadn't gone down that path. Anyway, those sort of two really key points, the kind of implied term and the local standards evidence, are not even been considered or mentioned in either of the consultations or in the draft directive, which sort of feeds into my point about it not really being about PI at all, this consultation, just sort of affecting us all by the science fight. It's unlikely that the regime under the package travel regulations is going to be looked at differently by the courts now. I think it would take a Supreme Court decision to do it. It's not impossible, but it seems unlikely. It would take some sort of legislative change to do it. And it doesn't seem like there's really much appetite for that. But if you're asking the question, which is the question that Ian posed us when he gave us the title, are they fit for purpose? I think that's one of the questions you'd have to ask. It's not just about how do you find a package and so on. I think that brings us to the end of what we were going to talk about, but we do have lots of time for questions, and more importantly, when we've done the questions, you can have a break, have some tea.
About 2:35, we'll be hearing from Sarah Crowther, Jay Gavin, and Sarah Jane Eaton about the defendant side of all this, indemnities and the like, which I am very much looking forward to. So let's start again about 2:35.